Welcome to another insightful discussion on contract law. Today I'm exploring the landmark case of Parker v. Southeastern Railway Company, 1877. This case is fundamental in understanding how contractual terms, particularly exclusion clauses, are incorporated into a contract. It raises a crucial question: can a person be bound by contractual terms they haven't read? Let's dive in. Background of the case. To fully grasp the implications of this case, let's set the scene. The 19th century was a time of rapid industrial expansion. Railways were transforming transportation and businesses were finding ways to limit liability through contractual clauses. But how enforceable were these clauses if the customer wasn't explicitly aware of them? Mr. Parker, an ordinary passenger, found himself caught in this legal dilemma when he deposited his bag at a railway station cloakroom operated by Southeastern Railway Company. The attendant gave him a small ticket in return. At first glance, it seemed like a simple receipt with a number on the front. However, what Mr. Parker didn't realize was that the back of the ticket contained a crucial clause. The company would not be responsible for any lost or stolen items. Legal issue. Now this brings us to the core legal issue. Was the exclusion clause printed on the ticket a valid term of the contract, even though Parker had not explicitly read or agreed to it? Parker's bag went missing, and naturally he sought compensation from the railway company, but the railway had a counter-argument. They claimed that Parker had effectively agreed to the terms by accepting the ticket. This case would test the principle of reasonable notice. How clearly and fairly must contract terms be communicated for them to be enforceable? Rule of law. In contract law, terms and conditions, especially exclusion clauses, must be incorporated properly. There are three ways this can happen. 1. By signature. If a contract is signed, the parties are usually bound by its terms, regardless of whether they read it. 1. By notice. If a term is brought to a party's attention before or at the time of contract formation, it can be binding. 1. By previous dealings. If the parties have regularly engaged in transactions where such terms were standard, they may be assumed to be incorporated. Since Parker didn't sign anything and had no previous dealings with the railway, the only way for the exclusion clause to be valid was if it had been clearly communicated to him. But was it? Let's examine what happened in court. Application of the law. In court, Parker argued that he had never read the clause on the back of the ticket and was not made aware of it. On the other hand, the railway company contended that it was Parker's responsibility to read the ticket and familiarize himself with the terms. This raised the critical question: had the railway company taken reasonable steps to inform Parker of the exclusion clause? The court examined past cases and the principle of reasonable notice. If a party wants to rely on an exclusion clause, they must ensure the other party has a fair chance to see and understand it. For example, in previous rulings, courts had considered whether the exclusion clauses were displayed prominently, whether they were written in clear language, and whether the customer's attention was drawn to them. In this case, the clause was on the back of a ticket that looked like a mere receipt. Since the railway company had not taken extra steps to highlight it, the court questioned whether the notice was sufficient. Verdict and conclusion. After reviewing the facts, the court ruled that Parker was not bound by the exclusion clause because the railway had not taken reasonable steps to inform him. The key takeaway from this case is that merely printing terms on a ticket is not enough. There must be clear notice given before or at the time of contract formation. This case set an important precedent for contract law, emphasizing that businesses cannot rely on fine print to escape liability. It reinforces the principle of fairness in contractual dealings. So the next time you receive a ticket, a receipt, or any document with fine print, remember the law protects those who aren't given reasonable notice. The end. Thank you for watching.